Hi everyone, today's session's 3.2a on contract law and it's learning outcome 4 we'll be doing today. In the last session we looked at learning outcome 3, which was to look at understanding the contractual terms and exclusion clauses, and now we will go on to looking at the legal issues of misrepresentation and mistake. So in the last session we looked at the difference between a condition and a warranty using case law. Explain how terms are implied within a contract and express terms. We looked at the importance and methods of incorporation. We also looked at the importance of construction for interpretation of the contract. Now we're looking at the legal issues of mistake and misrepresentation. So the learning outcomes of today's session is to distinguish a term of contract from misrepresentation, differentiate between the different types of misrepresentation, explain the categories of mistake which are common, mutual and unilateral and their impacts on the contract. So 4.1, we need to distinguish a term of a contract from misrepresentation. So misrepresentation is a form of statement made prior to the contract being formed. It's an untrue statement of fact made by one party to the other party which was intended and did induce the latter to enter into the contract. A contract entered into as a result of misrepresentation is voidable. An action for misrepresentation can be brought in respect of misrepresentation of fact or law. Misrepresentation occurs when one party provides misleading information that influences the other party's decision-making process, causing them to enter into a contract they would have not otherwise agreed to. It's important to note that it can occur unintentionally or deliberately and can be grounds for contract termination, legal action, or compensation. As stated earlier, misrepresentation is a false statement of fact made that has the result of inducing the other party to enter the contract. If misrepresentation is shown to have occurred, the effect will be that the contract becomes voidable. Now we're going to look at the remedies for misrepresentation. So the first remedy is rescission. It's very important in this section to identify the remedies available because they explain the different scales of damages available to each type of misrepresentation. So the first one we're going to look at is rescission. So this is equitable remedy available for all types of misrepresentation. Innocent party must exercise choice to rescind or affirm the contract. Effective rescission is parties are put back to their pre-contractual position. The notice is generally innocent party must notify the representor of the decision to rescind, and if impossible to find the representor, contract can be rescinded by the conduct of the representee. The aim of this remedy is to put the parties back into the position they were before they start the contract. Damages for fraudulent misrepresentation. Damages available in tort of deceit. Innocent party can recover all loss, including consequential loss directly flowing from breach. The representee under duty to mitigate loss once they discover fraud. An award for damages is the most commonly sought after remedy for misrepresentation. Although rescission is effective in releasing the parties from their obligations under the contract, there are often circumstances in which the damage caused goes beyond the contract in question. In this case, damages are an effective remedy. A fraudulent misrepresentation requires a high standard of proof. Subsequently, the measure of damages reflect the difficulty of proving this, and this was the case. This was the issue in the case of Doyle and Albee Ironmongers Limited, 1969, which is an authority to the effect that damages are awarded on tortious basis, aiming to put the aggrieved party in the position they would have been if misrepresentation was true. An example of fraudulent misrepresentation in regards to damages is if Party A sells Party B a car for £200. Party A is aware that Party B intends to sell the car on for £2,000. However, Party A has fraudulently misrepresented the make of the car and it only worth £50 resale value. In this case, it is reasonable foreseeable that Party B would lose out of the profit they intended to make on the resale, as Party A would aware of them attempting to resell the car, therefore damages could extend to those. For negligent misrepresentation, damages under Section 2, subsection 1 of the Misrepresentation Act 1967, damages are awarded on exactly the same basis as fraudulent misrepresentation. Therefore, the statement maker will be liable in damages for all consequential losses as a result of the statement, irrespective of the foreseeability. And this was confirmed in the case of Shaney Ford Suppliers Limited against Edge 1987. In this case, the complainant had entered into a contract to purchase land from the defendant. In this contract, it was expressively stated that there would be a vacant possession on completion of the agreement, and this would be ensured by the defendant. However, the current occupants of the land refused to leave, and they claimed for business tenancy benefits under the Landlord and Tenant Act 1954. In the course of agreeing the contract, the defendant had not served notice to the tenants regarding vacating the land. It was held at the court that the defendant was liable to pay damages to the complainant for failing to make sure of the vacant possession at the time of completion of the contract under Section 2, subsection 1 of the Misrepresentation Act 1967. He had not served notice to the tenants, nor had he offered to buy out the tenant's interest to fulfill the contract with the complainant. The occupant did have a legal right under the Landlord and Tenant Act 1954 to remain in occupation of the land. Damages for innocent misrepresentation. Under the Misrepresentation Act, Section 2, subsection 2, may give monetary relief in cases of wholly innocent misrepresentation, but it's up to the court to decide. Note 2, possibility to get indemnity in connection with action for rescission. As mentioned earlier, the only remedy for misrepresentation, innocent misrepresentation, is rescission, meaning damages will not be possible for innocent misrepresentation. Limiting liability for misrepresentation, that's contractual clauses attempting to exclude or limit liability for misrepresentation are construed strictly. 4.2, now we're going to look at the differentiating between the different types of misrepresentation. So the different types of misrepresentation that we have is innocent misrepresentation, where the party who made it did not realise it was untrue. Fraudulent misrepresentation, where the party who made it knew it was untrue or was careless as to whether or not it was true. Negligent misrepresentation, where the party who made it has a duty towards the other party arising out of a special relationship and therefore is expected to take additional care where it is foreseeable that the other party will rely on the statement. So we're going to go through each one. Innocent misrepresentation. So it is a misrepresentation made by someone who had reasonable grounds for believing that his the statement was untrue. A claimant who has put the victim on innocent misrepresentation can still pursue damages, but he or she cannot pursue rescission. To pursue damages, it must be shown that the claimant suffered a loss because of the misrepresentation. With the development of the Misrepresentation Act, the claim for innocent misrepresentation is extremely limited. A claim for innocent misrepresentation will arise when a claim for negligent misrepresentation under the Misrepresentation Act has failed. The remedy for innocent misrepresentation will usually, as mentioned earlier, is rescission of the contract. What constitutes innocent misrepresentation? Where someone must make a false representation, where the misrepresentation is material to the transaction, where the other party must substantially rely on the misrepresentation, where the lie must also approximately cause the other party to suffer damages, where the loss of one party must benefit the other. Now we're going to go on to fraudulent misrepresentation. Fraudulent misrepresentation is a civil tort arising out of contract law. It is a false statement of fact that causes or induces someone to enter into a contract. A defendant commits fraudulent misrepresentation when he or she lies or misrepresents an important fact about in order to cause or induce the other party to enter into contract. The misrepresentation can be in the form of anything that is designed to deceive the other party, including innuendos, half-truths, or silence when there exists a duty to speak. A fraudulent misrepresentation was defined in the case of Derry and Peake 1889 as a false statement which is made knowingly or without belief in its truth or recklessly careless whether it is true or false. In order to assess whether a statement has been fraudulently made, you should consider whether the statement maker knows the statement he has made is false, and as mentioned, or the statement maker has reasonable grounds to believe his statement is true if it is false. What constitutes fraudulent misrepresentation? The defendant made a false representation or lied. The misrepresentation is material to the transaction. The defendant made the misrepresentation with malice. So the defendant made the statement with the knowledge that the statement was false, or the defendant made the statement with a reckless disregard as to the veracity of the statement. The defendant made the misrepresentation with the intention of inducing the other party to enter into a contract. The other party reasonably relied on the misrepresentation, and the defendant's lie was the proximate cause for the plaintiff's injury. Case in regards to fraudulent misrepresentation was the case of Thomas Witter Limited and TBP Industries Limited 1996, which clarified that where a statement is made where the statement maker has no idea whether or not it is true or false, this statement would be fraudulent due to the recklessness asserting it is true when it may not be. True statements which become false, as we discussed earlier, in this, some statements may be true at the time of the statement, but later become false. In those situations, it was established that there's a duty for the statement maker to make the representee aware of this change. However, for the purposes of asserting the type of misrepresentation, would a failure to update the representee be classified as fraudulent? And this was identified in the case of With or Flanagan, 1936, which is suggested that misrepresentation as a result of a change of circumstances might result in either a fraudulent misrepresentation or negligent one. The next one is negligent misrepresentation. In the case of negligent misrepresentation, someone makes a reckless statement without any grounds of knowing whether what they are saying is true or false, knowing that their statement is likely to help them persuade someone to sign up a deal. If a car dealer claims to have believed that the previous car owner had kept their vehicle well maintained without actually knowing whether this was true or false, he may be committing a negligent misrepresentation. As we mentioned earlier, a negligent misrepresentation is made where the statement maker has belief in his statement but has been careless in reaching this conclusion. It is considered negligent as there has been a breach of duty of reasonable care and skill when making the statement. The difference between a negligent misrepresentation and negligent misstatement is the remedies available. So a negligent misstatement, a claim for a negligent misrepresentation that is based in tort under common law is usually referred to as the negligent misstatement. This claim was established firstly in the case of Headley Bryan and Company Limited and Heller Partners Limited, 1964, where there must be a special relationship between the parties, so there would be a duty of care which arises. The significance of a negligent misrepresentation under a tortious claim is that the aggrieved party has the burden of first proving that the duty of care and then proving that this duty of care has been breached, as we mentioned earlier. As will become clear from a claim under the statute is much easier to prove and therefore more favourable. The significance of a negligent misrepresentation claim under statute is that the burden of proof from the common law claim is reversed. Once the claimant establishes there has been an inducement from a false statement of fact, it is to the defendant to prove that they had reasonable grounds to believe the misrepresentation they had made was true up to and at the time of contracted. This is advantageous to the representee and thus a favourable action to bring. There's some cases here, leading cases on misrepresentation and the different types. For rescission, we've got the case of Carr and Universal Finance Limited and Caldwell, 1965. Fraudulent misrepresentation, we've got the case of Doyle and Albee Ironmongers Limited, which I went through briefly, 1969, which was affirmed in Smith Newcourt Securities Limited and Skimgore Vickers Asset Management Limited, 1997. We've got the case of negligent misrepresentation, Howard Marine and Dredging Company Limited, VA Ogden and Sons Limited, 1978. We've got innocent misrepresentation, which is Whittington and Sealhane, 1900. And then limited liability for misrepresentation, which is the case of Thomas Witter and TBP Industries Limited, 1996, which I went through briefly, and Entrepreneur Pub Company and East Crown Limited, 2000. So have a look at these cases in regards to misrepresentation. They will help you towards completing your assignment and also looking at the different types of misrepresentation. 4.3, now we're going to look at explaining the categories of mistakes. So there's common, mutual, unilateral, and their impacts on the contract. So firstly, to identify what mistake is in a contract law. In contract law, mistake is incorrect understanding by one or more parties of the contract. It may be used as grounds to invalidate the agreement. The general rule is that where a mistake has been made by the parties and it is an operative mistake at common law, the contract may be deemed void. Even if the contract is valid at common law, in equity, the contract may be voidable on the ground of mistake. The significance of the contract being void will be the essential characteristics of a void contract is that there will be no choice of the parties whether or not to void the contract. Under the law, it will automatically do so. This differs from the voidable position under misrepresentation. Mistake is a remedy which can arise either through the common law or equity, as I've mentioned, and the main case for that and the decision was in the case of Great Peace Shipping Limited and Savalaris Salvage International Limited, 2002, where it looked at limited mistake, mostly to common law. Types of mistake in contract law. So we've got common mistake, and this occurs This occurs where both parties make the same mistake with each knowing and expressly accepting the intention of the other, but each is mistaken about some underlying fundamental factors. Mutual mistake, this occurs where the parties misunderstand each other and are at cross purposes as to, for instance, the subject matter of the contract. And unilateral mistake, this occurs where one party of the parties is mistakenly the other, knowing or reasonably taken to know of the mistake. So we're going to look at each one. So common mistake occurs when both parties make the same error relating to a fundamental fact. So the parties appear to be in an agreement but have entered into the contract on the same misapprehension. Such mistakes render the contract void ab initio. An example would be, imagine that you enter into a contract to buy a piece of equipment. Additionally, you imagine that the other party did not realize that the equipment did not work. In that case, it's likely to be sufficiently serious common mistake. In this kind of situation, a court might be able to decide that contract was not created at all. Equally, it may also decide that contract had been created, but that your contract is void. Cases of common mistakes. So we've got res instincta, extincta, mistake as to the existence of the subject matter. Where the subject matter of the contract does not exist or ceases to exist, it may be void at common law. And the leading case for that is the case of Coteria and Hasty in 1956. In this case, a cargo of corn was in transit, being shipped from the Mediterranean to England. The owner of the cargo sold the corn to the buyer in London. The cargo had, however, perished and been disposed of before the contract was made. The seller sought to enforce the payment for the goods on the grounds that the purchaser had attained title to the goods and therefore bore the risk of goods being damaged, lost, or stolen. And the court held that the contract was void because the subject matter of the contract did not exist at the time the contract was made. And that's res sousa, where there's an agreement to transfer property from one person to another, but the buyer already owns the property and neither party is aware of this. The contract will be void at common law. And that's what happened in the case of Coutier and Hasty. In the case of Galloway 1914, in this case, both parties were under the assumption that they were married to each other, made a separation agreement. It was later discovered that the current marriage was invalid because, against all odds, the husband's former wife was still alive. It was held in this case that a separation agreement was void because it was entered in the mistaken belief that the parties were married to each other and therefore needed a formal separation. However, it transpired that the husband's previous spouse was still alive. Common cases of common mistake as to the possibility of performing the contract. So where the obligations of the contract are impossible to perform, the contract will be deemed void. And the leading case in this was the case of Sheikh Brothers and Osner, 1957, where the land was not capable of growing the crops contracted for, so the contract here was held to be void. Mistake as to the quality. So the general rule here is a mere mistake about one quality of the subject matter doesn't render the contract void. Common mistake can only void a contract if the mistake of the subject matter is sufficiently fundamental to render its identity different from what was contracted. And the leading case in this one was the case of Bell and Lever Brothers Limited. In this case, the facts of the case that Mr. Bell was the managing director for 5 years of a company that was owned by Lever Brothers Limited. Mr. Bell had traded for personal profit during his employment, which was contrary to his contract with the company. Without the knowledge of this, Lever Brothers made an offer of redundancy to Mr. Bell, terminating his contract, offering him £30,000 payment as compensation. The issue that came out of the case was that the main issue was in this case was whether the redundancy contract that was created and accepted by Mr. Bell could be void by common mistake due to later finding out about his personal trading. Lever Brothers Limited argued that this concealment and misconduct was a breach of his duty, and that was detailed in his employment contract. The court decided in this case, and it was held, that the contract was not void, as the mistake was not an essential and integral part of the contract. The Pearson trading that had happened during the employment was not related to the subject matter of the contract and was said to be a minor compared to the profits Mr. Bell had made for Lever Brothers Limited. Only a mistake to the identity of the parties or of subject matter to the contract, as well as items quality, would be able to be successful negate consent and therefore void a contract as if it had never existed. The mistake must be essential to the identity of the contract. Mutual mistake. This occurs when there's a misunderstanding between the parties as to each other's intentions. So the parties are said to be at cross purposes. A mutual mistake negates consent and the contract is considered void. An agreement mistake is one which fundamental is made, as I've mentioned, relating to the terms of the contract, which prevent the formation of a legally binding contract. The first examination of the agreement mistake will concentrate on mutual agreement mistake, where both parties that contract hold themselves to believe that the contract was intentional. And the case in regards to this was the case of mutual mistake was in Raffles and Wiltshire, 1864, where a contract was made for the purchase of some cotton, which would be delivered by a ship named Peerless, which sailed from Bombay. However, there was two ships named Peerless, which sailed from Bombay, one in October and one in December. One party believed the contract was for the delivery in October, and the other party believed it was for the contract was delivery in December. Therefore, as per offer and acceptance rules, there was no mirror agreement due to this mistake. This was a reasonable mistake to make, therefore the contract was void for mistake. The test for mutual mistake is that the courts will apply an objective test to the question of whether there's an agreement, considering whether one party's interpretation was more reasonable than the others. And the leading case, which was the leading authority for the test, is the case of Smith and Hughes, and the most reasonable approach to the contract was the one of the defendants who believed the agreement was formed based on sample oats. The doctrine of fault in mutual agreement is where the courts have identified that there's a doctrine of fault in the law of mutual agreement mistake, even where there can be a valid agreement. So if one party is responsible for the mistake of the other party, the court will decide the case in favour of the aggrieved party. And that was the case in regards to this approach of mutual agreement mistake was identified in the case of Scriven Brothers and Company and against Hindley and Company 1913, where in this case there was an auction for two lots of cargo from a ship. One was hemp and one was tow. The auction description did not list that the two lots of cargo had different contents. Both lots of cargoes were in the same packaging and there were no distinguishing factors between the two. A prospective buyer inspected one of the lots of the cargo, which contained hemp, and assumed that both lots contained hemp based on the identical packaging. He then purchased the other lot, which contained tow. The issue here is that the parties has formed an objective agreement for the specific lot, and there was no mutual mistake. However, as the mistake was caused by the auctioneer's actions of not distinguishing the two lots, the courts ignored this fact and the contract was void for the mistake. The key fact is that the defendant had no duty to examine the different lots, but the auctioneer did. Then we've got unilateral mistake, which occurs where only one party is mistaken and the other party knows about it and takes advantage of the error. So a unilateral mistake negates consent and renders the contract void. This form of mistake applies when one of the parties to the contract is mistaken as to the part of the contract, as I mentioned. Unilateral mistake is limited, but will usually operate in circumstances where one party is mistaken as to the part of the contract and the other party is aware of the fact and takes advantage of that person. Unilateral mistakes as to the terms of the contract. There's 3 requirements that will render a contract void for unilateral mistake in relation to the terms of a contract. Firstly, number 1 is one party is mistaken as to the term of the contract and would not have entered the contract but for this mistake. Secondly, the mistake is known or reasonably ought to be known to the other party. And thirdly, the mistake party is not at fault. So cases of unilateral mistake as to the terms of the contract. Unilateral mistake relating to the terms of the contract renders the contract void when one party is aware of the mistake and takes advantage of the other party's error. And the leading case in this is the case of Hartog and Collin and Shields, 1939. In this case, the defendant, Collin and Shields, were hide merchants that were based in London. The complainant, Hartog, was a furrier from Belgium. The defendants entered into an oral agreement with the complainant to sell him 30,000 Argentinian hare skins, and this would be at a price of 10D per skin. However, the defendant made a mistake on their written agreement that said that they would sell the complainant 30,000 hare skins at 10D per pound. This would mean that the price difference was 1/3 cheaper for the complainant than had previously been agreed. Hartog accepted this offer, but the defendants refused to fulfill the contract. It was held that there was no contract between the complainant and the defendant. Any contract would be void by the mistake of the hare skin price. The complainant would have known that it was normally sold per piece and not per pound. The court said that there's a duty to correct a mistake that is known to not be the real intention of the person making it. You cannot simply take advantage and snap up the offer. Unilateral mistake as to the identity. Where a mistake as to the identity of the other party to the contract is made, the contract will be deemed void if the identity of that person is central to the contract. So distinction to unilateral mistake. Contract made inter absentees, where the parties are not physically in each other's presence, so they are dealing by correspondence, and one party is mistaken to the identity, not the attributes of the other party, and intends to deal with some identifiable third party, and the other knows this, then the contract will be void by mistake, as in the case of Kundi and Lindsay. Distinction to unilateral mistake. Contract made inter presentis, where the parties are face to face. There's a presumption that the mistaken party intends to deal with the other person who is physically present and identifiable by sight and sound. For such a mistake to be operative mistake and to make the agreement void, the mistaken party must show that, number 1, that they intend to deal with someone else. Number 2, that the party they dealt with knew of this intention. Number 3, that they regarded identity as of crucial importance, and number 4, that they took reasonable steps to check the identity of the other person. So these are some of the references. We've finished the session now on learning outcome 4 in regards to looking at mistake and misrepresentation, and looking at the different types of mistake and misrepresentation with reference to legal authorities. And thank you for attending today's session. These are some of the references that you could use in regards to reading around case law, but also to help you with completing the assignment. Thank you for attending today's session. Thanks. Bye.